everybody, and welcome to another episode of North Alabama Law Review presented by Johnston, Weston. I'm your host, Shauna Hill, and today we have Mr. Christopher Weston and Mr. Bennett Driggers. Hey, guys.
Hello, hello.
So today we're going to dive into a topic about non-disclosure agreements and non-disparagement agreements. So guys, can you kind of start off by telling us the difference between these two agreements and exactly what they are?
Yeah, I'll jump in on this one if that's okay with you, Bennett.
Yeah.
These are becoming more and more common, especially in North Alabama, dealing with the arsenal. But the difference between a non-disclosure agreement and a non-disparagement agreement is pretty direct. So a non-disclosure agreement is your agreement to not disclose certain information about an employer, about somebody else, about a business deal, about a business proposition. These can be extremely broad. So, I mean, in NDA stands, again, for non-disclosure agreement. And when you're dealing with an NDA, is that can involve a litany of different situations, not just employment. Okay, these are very common, and you can even have them as part of settlement agreements in litigation. Whereas a non-disparagement agreement is similar but much more limited. A non-disparagement agreement is an agreement not to say anything negative about a company, a person, a situation, a resolution. And so while both are very broad, they each have their kind of own niche use. We see more non-disparagement in family law and disputed litigation, and we see more NDAs involving business deals. And so that's kind of the primary difference, is not saying anything or saying only very limited things about a situation or a person, individual, company, entity, what have you, versus agreeing to not say anything negative. And something people very commonly misunderstand about these is that limitation exists even if what you're saying is true under under an NDA. And a lot of times, even under a non-disparagement agreement, even though disparagement means negative, a lot of times it can be not saying something negative, even if that negative thing is true. It's not just anti-defamation. It is anti-disparagement. So even if something did happen and it was wrong, you can't say anything about it if you agree. And there are some limits on that. Ben, I'll let you take over on that side if you want to.
Yeah, well, essentially, a lot of lawsuits will settle in mediation or before trial. And so what happens is you'll have a non-disparagement agreement in those to protect each party. It's not just a one-way agreement most of the time. And if you're planning on doing one on your own, make sure you have an attorney read it over to make sure it meets the qualifications, things that need to be in there so that you don't get in any trouble later on. But essentially that's when it's done, maybe in a divorce agreement or whatever. You're agreeing both parties will not say bad things anywhere, internet post, anything directed at the other party to knock them down, to ruin their business, to ruin their reputation, whatever. So you got to be real careful with those. Once you enter them, they're enforceable. So our advice is to follow them to the T. Even if you want to say something bad, you really have to hold your tongue. You agreed to it. It was part of that agreement. Excuse me. You know, now on NDAs, I will say that you also, sometimes in lawsuits and things like that, I think Chris touched on that, but sometimes before you interview with certain companies, when they're recruiting you, they may have you sign an NDA because they're going to be sharing aspects about their company that they don't want to be made public. So that can be done also, but anyways, that's just kind of an overview, but that's one of the things you've got to look at. Anytime somebody's asking you to enter any of these agreements, an employment agreement or an agreement to not disclose private information from an interview or whatever, have an attorney look it over to make sure it's also protecting you and to make sure what your responsibilities are if based on that agreement or that legal document you're signing.
Yeah, as you mentioned, Bennett, you can find these agreements done, not only in personal life and business life, but like you said, mentioned in potential employment. If you're looking to possibly dive into a franchise, they'll probably make you sign an NDA to get that information. We see it a lot of times in celebrity news. We don't know the outcome. They signed a secret agreement, NDA agreement, not disclosing everything. But are there any limits when it comes to these agreements, or is it simply what you agree on, or does the court limit what you can and cannot put in these agreements?
Yeah, so I'm sorry, Bennett, that question was directed at you. Forgive me, I just jumped right into that one. I'm sorry. These are near and dear to my heart because, we need to get into some of the limits that the law puts in, but there's also, these can be very useful. And they're not just for large companies to use against an individual. A lot of times these may be things you want to do, even as a small business or as an individual. And then there's also some, pitfalls is that we need to go over on these because, again, these are becoming more and more and more prevalent. I mean, these used to be where you'd only come across these in very large business deals or sometimes company to company or in a letter of intent when someone was about to purchase a business. Nowadays, I mean, they are probably 1 out of every 3 cases when we're dealing with, high-end contractors or small businesses or honestly, just about anything anymore, especially with the rise of AI, and they say, give me an employment agreement. There's almost always going to be some form of language that could qualify as an NDA or a non-disparagement agreement. And so that can be a huge problem, especially with the language itself. So some of the limits that the law puts in there, but again, it's a gray area if you don't have it written into the NDA or non-disparagement itself. So always have it written in there. That's why Bennett was saying, have an attorney look over it because everything is progressive, okay? And what I mean by that is that everything evolves. It gets more nuanced. It gets more detailed. Contracts are no different. So a contract from 1975 is very unlikely to look like a contract from 2026. And especially with the rise of information technology such as PDF, email, all of that, people laugh about that because, Chris, that's been around for 40 years, right? 36 years at this point, since it became prevalent. But the problem is that in the terms of law and catching up, you can have somebody draft and spend all day, weeks, months, years refining an NDA or non-disparagement agreement in New York and Arkansas, out west, here, and have it transmitted all over the country, signed, scanned, stored, and kept. And so it makes it a lot easier for non-local contracts and agreements and NDAs and non-disparagement agreements to be used at a local level. And because of that storage capability and that ability to authenticate in court by whoever's the manager or whoever's the clerk regarding, their, contract storage, you can have a lot more restrictive agreements that are a lot more detailed and a lot more involved. But what the law does is if you are summoned to court, if you are compelled by court order, telling your accountant or your lawyer or your priest or your spouse about your, the terms of your non-disparagement or non-disclosure agreement. Likewise, the things that you went through at your, at that location or in that situation, you're going to be allowed to disclose because a court order, sometimes including a subpoena, will trump that. But again, it's something of a gray area. So practically speaking, because it became something of a gray area of, well, where's the line of denying a court order versus denying just a rule of civil procedure? And where is that line? In all of these agreements nowadays, what you see is language that says, yes, you can comply, but what you're going to be required to do is give notice to the other party. You're going to give them an opportunity to go to that same court, do what's called intervene, and say, hey, they're asking for this information that has been, by agreement, locked down for a good reason. And so it gives them an opportunity to argue it in front of whatever tribunal, court, what have you, that the other party in that case is using as a vehicle to demand information. Okay?
Let me add this. One of the things we see a lot of lately is AI-created documents. And nothing wrong with that, but I'll forewarn you, those documents can sound eloquent and sound legal and all the good stuff and be well written, but not be applicable to local law, which could be a problem down the line. So, again, if you're going down that road of wanting to create your legal documents AI, just be forewarned. There's nobody there to back up those documents for you if they're not correct. It's just you and whoever sues you over it. And then at that point, you're going to try to get an attorney involved that may not be able to help because of the local laws that exist, and you've put clauses in there that aren't enforceable or that are enforceable to an extent. So there's a lot more than just creating this beautiful looking document off of an AI generated platform. So be forewarned that could be a problem. If you go to an attorney, have them review that, and they do their job, that's better. That's going to support you more. So don't take the chances. It's a little bit of money up front to have someone review it, or it could be a lot of money on the end when you get sued over it. So look at it that way. It's worth, if you're in business especially, it's worth having somebody look over those documents. Because again, if an attorney looks it over, and attorneys aren't perfect, if they mess it up or if they draft a document and mess it up, they get to try and fix it, okay? And they have malpractice insurance that would help in that situation if you have to go that route. But the bottom line is, if you create it on AI, then you're ultimately going to be responsible for the results if you get sued over that document and you don't have a leg to stand on based on local laws and regulations.
Well, that, and along those same lines, when you're dealing with risk. So I've seen so many of these kind of AI-generated documents that come close but aren't quite there, right? That either are, just kind of general language from, kind of a national sampling of these types of documents. And what you'll do is you will read through them and go, that's close. Or it will create what's called ambiguity. Or it will lack what's known as a waiver clause. So basically what a waiver clause is it says that if one part of the contract is not enforceable, or if one part is waived by a party, it doesn't waive everything else, or it doesn't make everything else unenforceable. You also have what I've spoken about before, which are merger clauses, where it says, this is the only agreement. What's in writing here, what you're signing, every other form of communication outside of this is what's known as parole evidence, and can be excluded. But where this becomes very important is that if you create ambiguity in your document, if you create uncertainty, or it looks like it's almost enforceable or should be enforceable or might be enforceable, what you've done there is you've given whoever your opposing party is an incentive to litigate, okay, an incentive to roll those dice. And so that's where Bennett was talking about, a little bit of cost on the front end versus a lot of cost on the back end, is that creating uncertainty creates litigation. Okay, that's what it does. And that's a very, very important point. But one more thing I want to cover is that one thing NDAs or non-disparagement agreements will not allow is violations of federal law, such as whistleblower statutes, or criminal activity, or things that violate, discrimination laws, anti-discrimination laws. So they're not in and of themselves an end-all be-all a lot of times, especially in dealing with criminal activity, discrimination, dealing with whistleblower or federal law. But the problem that I have run into for a lot of clients, whether it's self-generated or something they just signed as part of an employment package, you run into a major problem where it's too broad. And if it's too broad, you've literally signed something where you don't realize the full scope of what you've signed. And that's becoming more and more of a problem, because let's say you are a professional and, you're walking in and you're learning the customer list or the pricing structure or the process or procedure of a company. Okay, fine. Those are the types of things that, a company would want to keep secret, and it is reasonable to, limit the disclosure of that. However, in a lot of these professions, especially engineering and some of these, operation management fields, where just because they're doing it that way, that doesn't mean that everybody wouldn't do it that way. That doesn't mean that it wouldn't be common sense. And so a lot of times NDAs do not permit, limitation on things that are either public knowledge, something you knew in and of before you started there, something that is part of your general profession, because Alabama and pretty much nationwide does not like to limit people's ability to practice their profession. However, this is where you get into a gray area. At what point is it just common sense in your field versus a specific process or procedure or customer list or vendor list or pricing list that company uses in and of themselves? And so again, you have now walked into ambiguity that you may not have meant to walk into, and that can open the door to litigation and trying to limit a competitor. This is very true among very skilled employees where they knew how X, Y, and Z would be done before they walked in the door, but they've now signed an agreement as part of an employment contract that says anything you learned or saw in this, in this arena at this employer, in this company, you cannot disclose or use. And that's what I'm bringing up. There's use restrictions in a lot of NDAs. So just be aware.
They'll also put in there things you create while you're employed with the company, belong to the company. So you can go in there and invent some great aspect of their operations for them, but you won't be allowed to take that invention, so to speak, with you when you leave. So be very careful again. I just wanted to add that part.
A lot of litigation on the side of did you do it on company time under the agreement or on your own time separately, and there is a lot of litigation on that. And really the main pitfall here is people are signing these and they're like, well, this makes sense to me to limit the disclosure of my, my new company's information, and they just sign it as part of an employment packet. And then, they get 5 years down the road and you're walking into all kinds of uncertainty. And same thing with AI contracts is where, it seems very reasonable that, this is limited, but if one clause competes with another clause, even inadvertently, we've had a lot of litigation where it leaves it up to the discretion of the trier fact, whether a judge or a jury, to say, how do they think that reads? Or we've even seen imputed terms where it's like, well, they got a benefit for it, or you got a benefit for it. And so now I'm not going to enforce it, and it's ambiguous enough where it makes appeals very difficult. So be careful.
Yeah, I mean, I've had compliance sit there and wonder, well, I was the brains behind this. I invented this, but you did it at work, and you were doing it as an employee of this company, so it does not belong to you. And that can be very disappointing, to say the least, because they're right. They were the brains and the cog in the wheel that made that invention turn, yet it doesn't belong to them because of that agreement. So, again, be very careful.
You don't want to sell a multi-million-dollar idea for a $20,000 signing bonus.
Yes.
Good
very, very true.
Right,
You
like,
could be signing over something that could be life-changing for sure.
Right.
Yep.
Well, let's talk to the younger generation just for a moment on these non-disclosure, non-disparagement agreements, because you mentioned AI a lot, which we mentioned that heavily on having an attorney double-check anything you create, especially if you're using AI. As they mentioned, the devil is in the details, especially in the eyes of the law. It's what you can argue and how you interpret it. So those details definitely matter. And these guys they will write a contract that is ironclad and to the best, to your business or whatever you're trying to achieve. But still touching on the basis of AI and technology, a lot of our younger generation uses social media. So can we just kind of break down when they are entering these NDAs, non-disparagement agreements, what should they do or not do when it comes to social media? Just want to make sure we make that line very clear.
I want to touch on this too, and then on the social media aspect, Ben, if you want to jump on that, you probably know more than I do. I avoid social media unless it's literally for business purposes, because I want people to know what we can do for them. I'm just not very good at it. But I do want to say this. Understand, like, we're not trying to insult AI drafted documents or to tell you not to use these things in general. These can be very effective tools, but be aware that when we draft something, just like when anyone else drafts something, there's several different versions. You know, it gets modified, it gets redrafted, it gets amended, it gets edited. And so the problem is when you're on AI, you're basically creating a draft. But if you don't know how to evaluate that draft, just like when anyone else drafts something or creates something or writes something, you're not going to know where it needs to be amended. I mean, very rarely is there an agreement or a contract where it's like the first one is absolutely perfect. So it's not so much don't use these things as it is just understand you're creating a first draft.
Yeah, and understand that also, because we've been doing this a few years, we know the pitfalls of contracts and what works, what doesn't work. And you have to draft a contract to specifically fit the needs of that agreement. And that's some of the things that you won't be aware of without somebody that's got experience drafting these things. Is, you know, you won't know what to look for, and I'm not saying the viewers aren't smart. I mean, from a legal standpoint, you won't know what to look for in terms of, okay, we've had this in a contract before, we went to litigation with this, and here's what the ruling was, and here's what the appeals court held up. Things like that come into play, and just drafting a contract on your own, it may be perfect language, except for it doesn't fit the exact needs or wants of your situation, and then you might think it does, but it won't cover one of those aspects I was talking about where, yeah, we have legislation, but we also have case law that's changed the way that's viewed going forward. So that's one of the things that an attorney will do for you, is they'll make sure that it fits within that realm of, okay, this will work, however, case law has overturned this type of drafting for such and such a reason, and here's what you need to add instead of this, you know. So those are the pitfalls of doing it yourself. And like Chris said, AI is a great tool. We're not knocking that. It does generate some great stuff, but it won't take into consideration the pitfalls that we've seen in litigation and in trying to enforce these agreements. So keep that in mind.
Yeah, the best wrench in the world will not make you a good plumber. That's why I think.
That's a good analogy.
So sorry, social media goes by the terms of the agreement. You're putting something in a public forum. Don't count on a loophole or a technicality to get you out of an agreement simply because you put it on a public forum that happens to be electronic. That's kind of my advice. And I know we need to get some questions, Shauna, but this is one of those things. There are lots of things you can do in law yourself, but signing any form of detailed term-specific agreement, you really do need to be careful because they are getting more sophisticated. That's kind of the main point that I'm trying to make on that.
And screenshots do exist. They are used as evidence all the time.
Oh, yeah, they do.
Once on the internet, it never goes away.
Even I know how to take a screenshot at this point, and I am the resistance.
Well, but let's jump into a couple of questions since we got a few minutes left. So the first question is, can an NDA stop me from talking about a business dispute publicly?
Yes.
Absolutely.
Yes, it can.
That's the whole point of it, most likely, of them having you sign it, is to not talk about it on a public forum.
And that's, again, speaking of Ron White, watch his watch his view on when he went to a certain tire place. He started talking about it. It was hilarious. Sorry, I'm not trying to give him a shout out. That was just a funny bit. But yes, short answer is yes. Yeah.
Well, Ben, I'm going to throw the next question at you. Are NDAs only used in employment situations?
No. No, they're, again, commonly used in all kinds of situations dealing with litigation. Could be employment, employee, employer. It could be a contractor for an employee or for a company, I mean. So there's a lot of situations they can be used in. So just keep that in mind, especially if you're an independent contractor doing work for different companies. You could be running into an issue with that if you represent more than one company. A lot of times these come into play when you're in sales and you decide to take an extra sales job on the side, and you may right then and there be violating any kind of NDA or an agreement. So just be very careful.
Yeah.
Well, I do want to get at least one more squeezed in, is what is the biggest mistake people make before signing these agreements?
Oh, my goodness.
We only have 1 more minute.
Okay, I've got to say it. I'm going to jump in. Sorry, Betty, I'm jumping on this one. Not understanding the difference between disclosure and use. These are two very different things. And understand that little 3-letter word has caused more litigation on these types of issues and in these types of agreements than I can easily describe. Use. U-S-E. That is the biggest mistake, that they go no disclosure or use, and they think that means using it for someone else's benefit. It does not always mean using it for someone else's benefit or at someone else's discretion, okay? It can mean using it at all. And when that comes to information you have opened up a door you do not want to open.
Well, that's one of the, I'm sorry, Chris.
No, please.
That's one of the things you need to understand, what information is being protected there. Because if you don't know what's being protected, I can guarantee you're going to violate it.
Mm-hmm.
So have a good understanding of what's going on with that agreement and what information the company or the other party is trying to protect.
Oh, and let me say this, I'm sorry, that triggers something. Again, this goes into contract law, again, near and dear to my heart. I will tell you, inadvertent violation of one of these agreements is not a defense. It can limit punitive damages. It can limit some punishment damages, which is what punitive damages means. It can limit some multipliers in certain instances, but it is not on its own, absent language in the agreement saying otherwise, a defense. And that is a huge pitfall with these. And so this is one of those times where you need to tread carefully and don't be in a rush. So I guess the other biggest mistake I see is people being in a rush.
Yeah.
They want the job, they want the contract, they want the information, they want the sale, and they get into a rush. Be careful. Is that famous saying, slow is smooth and smooth is fast.
Mm-hmm. Well, that's a lot of great information. Thank you, guys. We've ran out of time for today, but if you want to learn more, send us an email at legalhelp@jmmtlawfirm.com. We'll be happy to answer them on air. See you next week. Have a good weekend.